Good morning. Thank you for tuning in to YNA Network. W- on this channel, we provide information about finance, the world economy in general, the blockchain technology. We don't provide financial advice, but a better way to research one's interest before investing. So let's go ahead and listen to this audio.
Securities and Exchange Commission versus Ripple. 2-year crypto beef could soon be settled. Ripple has been fighting the Security and Exchange Commission's allegations that it held a $1.3 billion unregistered securities sale since the Security Exchange Commission filed its court case in December 2020. Now the Commission and Ripple have filed for a summary judgment from US District Judge Annalisa Torres on whether XRP qualifies as a security, based on the evidence that both parties submitted so far. To qualify as a security, XRP would have to meet the conditions in the Howey test, which states that an asset counts as a security if the investment contract involves an investment of money in a common enterprise with the expectation of profit to be derived from the efforts of others. Ripple denies XRP passes the Howey test. Ripple denies that XRP qualifies as a security, claiming that sales of the token never included an investment contract. Its filing for the summary's judgment said, quote, the Security and Exchange Commission's untethered position would convert the sales of all types of ordinary assets, diamonds, gold, soybeans, cars, and even works of art, into sales of securities, end quote. Investors typically regard diamonds, gold, and soybeans as commodities, something that the Commodity Futures Trading Commission would normally regulate. Ripple claims Security and Exchange Commission conflict of interest. In April 2022, the watchdog group Empower Oversight obtained emails between the Commission's ethics office and former Commission Director William Hinman through a Freedom of Information request. The Security Exchange Commission's Ethics Office expressed concern about a possible conflict of interest, since Hinman had a financial stake in a law firm called Simpson, Thacher and Bartlett. Simpson, Thacher and Bartlett joined the Enterprise Ethereum Alliance and advised the Ethereum development team on legal matters. The Security Exchange Commission Ethics Office pressed Hinman to either divest from the firm or rescue himself from any issue that could affect Simpson, Thacher and Bartlett. Hinman did not divest and rejoined the firm as a senior advisor after leaving the Security Exchange Commission. He reportedly made millions from his association with Simpson Thacher during his tenure at the Security Exchange Commission. While working at the Commission, he made a famous speech in which he opined that Ethereum was not a security. Now that Ethereum has switched to a proof of stake algorithm with successful activation of the merge, it seems like the Security Exchange Commission disagrees. Predictably, Ripple's defense team latched onto the files obtained by Empower Oversight's Freedom of Information Act request. It claimed that the files indicated a conflict of interest when dealing with the similar Ethereum. Even before Empower Oversight obtained the documents, including proof of a potential conflict of interest, a federal judge dealt setbacks to the Security Exchange Commission's case against Ripple by ruling that the Commission cannot claim confidentiality in documents that include a draft of Hinman's speech. Since April 2022, Ripple has used the documents obtained by Empower Oversight as an important part of its legal defense. The Securities and Exchange Commission disputes Ripple's claims. The Commission disputes Ripple's assertion that it didn't know Ripple qualified as a security. Quote, defendants made a calculated decision to risk a Security Exchange Commission or private lawsuits in order to profit by over $2 billion and cannot now feign surprise that the day in court has come, end quote. It points to Ripple co-founder Brad Garlinghouse's 2018 tweet denying that regulatory uncertainty existed in crypto markets. He called regulatory uncertainty a euphemism for, quote, we wish we could ignore Security Exchange Commission regulations, end quote. Where do Ripple-related airdrops stand? Holders of XRP may recall that there were a few airdrops. However, not all of them went smoothly. The Spark token airdrop should have happened in December 2020, and a snapshot of XRP token holders occurred on December 12, 2020. However, the airdrop faced a series of delays, finally occurring in March 2022. Even before the Spark token airdrop should have originally occurred, the IRS began scrutinizing airdrops. The IRS revised Rule 2019-24 classifies digital assets as virtual currency, but is subject to income taxes. Solargenic's Solo token airdrop established that airdrops can still impact a digital asset's value. XRP jumped by 10% before the airdrop occurred. Large XRP token holders also moved millions of XRP before the airdrop. Members of crypto Twitter previously warned that 99% of XRP-related airdrops are scams, while surges in activity related to airdrops caused XRP nodes to slow down or reboot. The issue impacted Ripple's S1 and S2 nodes. Even one XRP-L Labs engineer admitted that the ledger needs fixing, if surges in activity could cause nodes to crash. If Judge Torres rules that XRP is not a security, Ripple and XRP investors could claim victory. Since the filing for the summary judgment, some digital asset investors have been snapping up XRP in a bet that Ripple will come out on top. XRP's price jumped by just over 12% over the past 7 days, pushing it to number 6 by market cap on CoinMarketCap. For more informed news, follow us on Twitter and Google News, or listen to our investigative podcast, Innovated Blockchain City.